case briefs, and so much more. LSData's got what you're looking for.
In 1990, the United States Court of Appeals for the Ninth Circuit presided over the case of 3,550 Stevens Creek Associates v. Barclays Bank of California, focusing on whether the installation of asbestos in a building constituted disposal of a hazardous substance under the Comprehensive Environmental Response, Compensation, and Liability Act, CERCLA, of 1980. Prior to the lawsuit, 3,550 Stevens Creek Associates renovated a commercial building and sought to recover costs for asbestos removal from Barclays Bank of California, a previous building owner. After filing the lawsuit under CERCLA, the district court granted judgment on the pleadings, deeming there was no legal authority for the award of such relief. The appeal posed the question of whether a private party could recover response costs for cleaning asbestos from a commercial building in light of CERCLA's definitions of facility and hazardous substance. Ultimately, the court held that the plaintiff could not recover response costs for asbestos removal since materials containing asbestos were not considered disposal under CERCLA, and Congress had not intended to create a private cause of action for cost recovery in such cases. The appeal was affirmed, maintaining the district court's decision.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.